I'm Carol Lawson, a Clearwater estate planning attorney. Here's 6 mistakes people make when they have a revocable living trust-based estate plan. Mistake number 1. While you likely own non-probate assets like IRAs, life insurance, that avoid probate by you naming beneficiaries, you need to transfer your probate assets like real estate stock accounts and business interests to your trust during your lifetime, because only assets that are already titled in your trust when you die avoid probate. This retitling process is called funding your trust. Mistake number 2, not getting the trust designations right. It's likely that decades will pass between the time that you create your trust and the time you pass away. Lots can change during that time. Make sure you make the right decisions regarding the first trustees, the alternate trustee, individual or corporate trustees, when you will use co-trustees, what happens if there is a vacancy in the office of the trustee, and can the beneficiaries perhaps unanimously remove a trustee? Is the trustee entitled to compensation? Does your trust enable your trustee to make deathbed tax savings transfers or handle digital assets? Can your child, who was a trustee, self-deal and purchase assets from the trust, like your home, so long as it's for fair market value? Mistake number 3, over-relying on POD and TOD designations, transfer on death and payable in death, are generally a good thing because financially institutions are reluctant to use powers of attorneys. It's easier for your successor trustee to handle accounts and real estate when you become incapacitated. If you go ahead now and move those accounts and assets into your trust, and TOD, POD designation forms are also very rigid with what happens if a beneficiary predeceases you. Many of these forms require that the accounts be payable to the surviving beneficiaries. If a TOD beneficiary predeceases the account owner, most accounts owners want a child that predeceases them share to go to the child's children. That doesn't happen with the bank. Mistake number 4, too many people make false assumptions about living trusts. Common false assumptions include the trust needs a tax ID number, that trust is excluded assets for state and federal tax purposes, but trust assets are not countable resources for long-term care Medicaid eligibility. If you reside in a nursing home, that trust assets are exempt from your creditors in full. Some people falsely assume that avoiding probate simply by having a last will and testimony. This assumption is false. Mistake number 5, failing to document the trust assets. If you don't maintain a thorough record of all the accounts and assets titled in your trust, you're likely to send your successor trustee on a wild goose chase when you die, making the trust settlement more complex and lengthy. Our real estate plan helps you transfer your assets, locate your assets, and provide your successor trustee all the support that they need at their fingertips. Mistake number 6, acting too quickly after the original trustee dies. The fact that the trust assets can be distributed so quickly after the trust settler dies can be a blessing, but occasionally it's also a curse. The trustee is responsible for paying the trust bills and debts, and if the trustee distributes funds to the trust beneficiaries upon the settler's death, the trustee could be in a position of having to go back to the beneficiaries and ask them to return a portion of their inheritance to cover expenses that were not taken into account prior to the trust distributions. I hope this helps.